Securitization. 3 banks securitize mortgages by selling them to a SPV, a special purpose vehicle, a trust. Then they create bonds of trust assets to sell to DDC. The bank cannot foreclose on the note, because they are not a holder and lack standing. However, the mortgage contract requires payments. This makes the note non-negotiable. They are foreclosing on the contract under common law, not the note. The bank claims to be holder in due course, but that is not possible for there to be a holder in due course of a non-negotiable instrument. Non-negotiable instruments are governed by common law, not the UCC. SPVA. Special purpose vehicle, an organization constructed for a limited purpose and life. Frequently these SPVs serve as conduits or pass-through organizations or corporation in relation to securitization. The entity that hold the legal rights over the asset transferred by the originator. The originator of a mortgage is the living man. If he is the originator, the SPV becomes the legal holder when the deed is signed. The bank is acting in the capacity as a servicer. When you are involved in a foreclosure case, the straw man creates an illusion. No party is real, so the real parties in interest are not involved in the court. The bank may be named as the plaintiff on the foreclosure as the servicer. The real party in interest is the SPV. Patriots usually ask the plaintiff to produce the note. The note is not a negotiable note because it has terms and conditions associated with the instrument which could lead to a question as to whether the terms and conditions have been met. A negotiable instrument can have no restrictions, terms or conditions. 1. The note is non-negotiable. 2. It is never registered in the public. These instruments cannot appear in a court. If it was brought into court, the judge would see that it is not registered, and would claim he has no subject matter jurisdiction over your claim. Secondly, it is not negotiable, so it does not come under the UCC Negotiable Instruments Act. Consequently, it comes under contract obligations, so the appearance of the notes is immaterial and irrelevant, especially since it was never registered in the public. The next problem is, since the note is not registered, what standing does the plaintiff, bank, have to be there? Under the UCC, the plaintiff has no standing if he is not a holder in due course. The plaintiff is not there on the note for several reasons. It also shows that the bank is liable and the originator is the creditor. The note is an asset to the defendant, which is a counterclaim for recoupment. It does not support the bank's case. Before closing, the note goes into an SPV which now has legal title to these issues, and it creates a new instrument in the place of the note. They create securities and bonds, which are registered. The plaintiff is representing the registered security and bond at closing. They are hiding the P under several shells so you don't know where it is. This keeps the patriots from making the proper claims. Gene Keating. The statute says you have a right to restitution and rescission if they sell an unregistered security. Ohio Statute 1707-261. Is the note an unregistered security? It is a non-negotiable instrument. When they convert it into a security, it takes it out of UCC Article 3. It could be under UCC Article 4 because it is deposited in a bank. But eventually, after it has gone into the SPV and been securitized, it is moved to UCC Article 8 and Article 9 is applicable to the remedy. They have to give you the right to rescission because it is unregistered. So, they ledger that you no longer have a liability by giving you the set-off. So they are following the law. But they are keeping the records in 2 different sets of books like the mafia. We are following the letter of the law and showing them what they're doing. We have a right to rescind and restitution, which is also part of recoupment. We can go to the NASD, the National Association of Securities Dealers. They have an arbitration and resolution board located in NYC. They have tribunals in each state for hearings. You can go to arbitration and have the contract rescinded and get restitution because they are selling unregistered securities. I have examples of 4 recent cases from 2005 and 2006. People have purchased promissory notes and found out they were unregistered securities. There is case law on this. This is money laundering or RICO. But there is a statute protecting us. Since, as soon as they sell the unregistered security, we are entitled to set off to settle the claim. We are raising this claim. We have not waived it. They have not addressed our claims or defenses, So we have grounds for appeal. The law requires them to do this because they have raised it. One can stop any mortgage on this basis. They would be better off if the judge gave you a remedy on other grounds. We have given them several grounds for rescission. They can also allow rescission because the property is in a floodplain. Their attorney said that if what we are saying is true, it would destroy the mortgage market. We had an attorney say the same in her pleadings 15 years ago, and then she was taken off the case. I don't think they like attorneys saying those things in public. Federal court threw out our RICO complaint initially. I brought up the FASB and IASB standards and regulations in appellate court. I corrected them from stating that the bank is the creditor. That is only true on the receivable side of the ledger. We are the creditor and they are the debtors on the liability ledger. That provides a remedy. The G7 has endorsed it. Now we are getting into international law, with the IASB standards that they have adopted. These standards say we have a right to set off. So, like the mafia, they always have a second set of books that are not available to the public. They only use the public books when they make a claim against us to determine how much we know about our claims available on the other side of the accounting. It is up to us to bring this claim or waive our remedy. Most CPAs are not familiar with these issues, because they don't have to deal with them. Bank One uses KPMG to audit their books, others use Price Waterhouse. They are international auditing services. They are expert at auditing off-balance sheet accounts. There is off-balance sheet financing, payables and receivables. These auditors are the only ones that are aware of these issues. Scott Taub is the chief accountant for the SEC and his assistant. They confirmed my information. The SEC is also the enforcement agent for this practice, because it involves securities. He admitted that this is their practice. He wanted to know who I was, but I did not tell him. One bank auditor wanted to know why I was asking these questions. What does why I am asking have to do with question? Are going to tell me what you are going to do with my note? Don't I have a right to know what you are doing with my note if I go into business with you? Everybody thinks a note is a liability, but it is not. Under UCC 104(c), it says that the originator is the sender of the first fund transfer. We are the first funds transferor. UCC 105(c), subsection talks about issue and c talks about issuer. It defines the issuer as the transferor of the first fund transfer, which is the drawer and the maker. UCC 8102, 12, 15, and 9 that define what an entitlement holder is. UCC 8105 that says we are identified as the person with securities and entitlement right on the books of a banking intermediary. They call them intermediaries under Article 8. This practice is all under Article 8 because it involves securities. That is how they are hiding their practices. They are treating these notes as securities and not Article 3 paper. Under Article 8 we are the holders of entitlement and possessory rights to the proceeds of the transaction because we are the originator of the first funds transfer on the accounts payable side of the ledger. We are entitled to the funds. A promissory note is an asset to us. When we give it to a beneficiary and he deposits it, it becomes a cash item to the bank. They issue a cash receipt to the depositor. The bank gets a cash receipt that is the equivalent of money. It is what passes for money in the society. They will tell us that our note is not cash. But after it is deposited it looks as if we deposited money in an account. This is a cash proceed under Title 12 of the USC. We are the creditor and we are not bringing this up as a defense. This is why there cannot be a holder in due course. UCC 3302 defines a holder in due course. It says in the first paragraph that the section a holder in due course is subject to 106(d). That says that where an instrument is involved, there cannot be a holder in due course. The reason they can't is because they are taking it subject to the defenses and claims that the drawer and maker as the originator of the first funds transfer can bring against the payee, which is the bank. The reason there can't be a holder in due course is because we are the creditor and we can trump any claim that a holder might have on that instrument. The claim that the originator and maker can make is set off because they sold an unregistered note. They cannot be a holder in due course because they are taking it subject to administrative and commercial claims every time there is a clause in the instrument. They create a mortgage purchase loan, 16 CFR 433.1. This whole process is not about mortgages at all, because they sold the note and received the funds and closed the account by assuming they have repaid the originator on the loan. If they already repaid the originator on the loan, the living man who signed the note, then the whole thing is closed. We got our money back. We did not receive the money or ask for the note back. So the bank transaction on the payables side shows that we brought the money in, they credited our account so they paid it back. We don't have a claim against the bank. It stayed in the account, because we didn't claim it. So they assume it has been abandoned. A trustee of abandoned assets would normally invest these assets to make money on them. They are expecting rent for this property from us. We are not paying monthly payments of principal and interest. It's because the loan has been paid off. We are paying rent for the asset we failed to collect. The SPV is taking all the payments as profit. It is under contract and has nothing to do with notes and contracts. It ends when the original contract is finished. If you stop making payments, no one has been damaged. The only reason the banks continue to collect for 30 years is because you are a fool. We are responsible for agreeing to this contract. We don't have a claim for fraud. We did the first funds transfer that they transferred to the receivables as an asset to the bank. When they didn't give the note back, the bank sold it or deposited it as a cash item. UCC 1204 says we are considered as merchants at law, who know what we are doing. We act as though we are experts at negotiable instruments. That is how they get around the defense of fraud in the inducement. To prove fraud in the inducement, one has to prove he didn't know what they were doing, and didn't have sufficient time to find out. But in order to prove that, you have to learn how to do it right first. They call their process de-recognition. But most of the time that is not true. If they pass the reward and the risk, a complete sale of the asset, it is de-recognition. De-recognition is defined in accounting as not recognizing it on their books anymore, or removed it of the balance sheet. This means they extinguished the loan from the books. We are asking for the balance sheet in discovery. The balance sheet will show that the loan has been extinguished. They are trying to collect on a note that they have no right, title, or interest in. PIMCO on bonds, using the real estate is not the mortgage loan. It is used to securitize the commodities and securities exchange. They are not using mortgages to attach property, because it only appears that they got an interest to attach the property. We have the priority. Their real intent is to create derivatives to create a security and bond market to finance all commercial and corporate activity. Tying up the land is a profitable byproduct, because nobody understands that they don't have a claim for it. They are called beneficial interest holders, BIHS. Those are the organizations with an account with the DDC to buy the mortgage-backed bonds, which are the pooled assets from the HELOC or trust. End of Gene transcript. Victoria conversation. There is no difference between a civil case, a criminal case, or a mortgage deed and mortgage loan purchase. Victoria had a couple traffic cases back in early 1990s. Victoria was in jail for a while. She was jailed for 6 months in 2001 based on a personal complaint, but they discovered an old warrant for her arrest. She attempted to get the feds to prosecute the county under Title 42 because the judge had said that the warrants had expired. She settled and closed the probation with a note. But she recently found an old warrant poster on her on the internet. She found out that a Hong Kong investment company purchased her criminal case bond. It is possible that she didn't have standing to ask for a Title 42 lawsuit, because she had not filed a Bailey-Baylor agreement and therefore, she was not a creditor. One must be a creditor to make a claim. Everyone today is presumed to be an enemy of the state, a U.S. citizen. This game is played in Admiralty Maritime Commercial Law. When you file a UCC 1 Baylor-Bailey, you are saying that I want to be a creditor. A creditor in an Admiralty transaction is the same as a sovereign with inalienable rights in common law. It is a way of colorably stating that I have standing as a creditor to get a remedy. You are the creditor in their payables books. As a slave, you can only plead guilty. But without the UCC 1, you didn't have any documents to show that you could come in as the creditor on the liability account of the corporation. If you can come in where the de facto government owes you instead of having the de facto government claim you owe them, you have a counterclaim for a set-off. Patriots want to use the common law, But the government is focusing on you as a debtor by a voluntary contract of servitude. The government treats you like a slave unless you know enough to understand how a slave can pay off his debt and get his liberty and freedom. They are speaking in a different language so we don't understand, asking for our liberty presuming we don't have a debt. We languish in a foreign jail because we cannot understand the remedy. How do I get them to acknowledge this so I can come in with standing as a creditor? Do I send a precept to the clerk seeking his acknowledgement and his appointment of this attorney? She has not received an answer back from the Secretary of State of Puerto Rico acknowledging her filing. If there is no filing number, what document do I have to show there is a BB agreement to give me standing in the court to direct the Title 42 action to appoint an attorney to go after the state for its unlawful actions against the straw men because they didn't have a valid warrant? Once you do your BB filing showing the relationship, then you can bring that document in. Just like the collateral being the note in a foreclosure case, the collateral in the criminal case has to be our signature on our note that we gave them in the criminal case for the settlement and closure. That is your claim in that criminal case. The note we gave the bank was the claim in the foreclosure case. That is your asset. One should not put the indictment and the collateral on the UCC, because it is a liability to you and an asset to the corporation. It is their account receivable. The IBO that you sent them is your asset and it constitutes your claim. Victoria gave them an IBO to settle the case. They have not returned the note or settled the account. This is just like the bank mortgage. The mortgage deed is still recorded after you gave them the note. But when you gave them the note, they closed the account. But then they sold the note for other investments to other corporations off the balance sheet in the background. How can you show them that you have an ongoing interest in that note to settle that account? Have you been making monthly payments to show an ongoing interest in the note? For an example, you purchased real estate. They give you a deed. They recorded the deed. You got the mortgage deed. You got the mortgage note and you got the mortgage contract. The mortgage deed is superimposed on top of the deed. The mortgage deed has priority because it was filed last and it is sequenced with the same party that is on the deed. The public looks at the mortgage deed and it appears to be a legal, lien hold interest in the property. It is not a negotiable note. A Federal Reserve note is a negotiable note that is registered as a security. So the FRN passes in the public. If you deposit FRN with a deposit slip in the bank accepts the deposit as a cash item and they give you a cash receipt. They do not that when you give them your note, because it is non-negotiable and not registered in the public. So the transaction does not appear on the public side of the books because there is no public registration. It does appear on the private side of the account because the note is private. When your note comes into the bank, they offset the private side of the account, but they can't offset the public side because it isn't registered. So it cannot appear in the public side to offset the public side of the accounting. We use monthly payments to show the public that we have interest in that property. Legal title to the note has been transferred to the SPV. So you no longer have legal title to the property. We must use the monthly payments to show we have claim to the property, because it was our own note. We make monthly payments on the mortgage and the utilities and yearly payments on taxes. If we were not paying those, we would have no receipts to show that we had any continuing interest in the property. If we filed an interest in the property as a creditor, we would not have to make all those monthly payments in the property. We can choose to be a creditor or debtor. But if you are a debtor and stop making payments, the presumption will be that you are abandoning your interest in the property for possession and use. You already abandoned the legal title. The bank can step in and take over because of another level of abandonment when the mortgage deed is still recorded in the register, but when you gave them the note they closed out the account. Then they sold the note for other investments to other corporations off the balance sheet in the background. How do they prove that you have an ongoing interest in that note that you gave them to settle that account? That is why you make monthly payments on that note that you abandoned to show that you have an ongoing interest. You have to provide an application with a name, address, and an SSN to sign up for a utility on the property. The SSN is the trust account that is prepaid. So you sign up for your utilities with your prepaid account. Within 30 days, instead of giving them a BOE on the prepaid account, you keep coming in with liability notes to keep showing a debtor interest rather than a prepaid interest on the account because you failed to register. The application for the utilities is the equivalent of signing a negotiable instrument or a private note. Because your unrestricted signature with the account name and number is equivalent authority for the utility to keep drawing off of your prepaid account to run their corporate utility business. You show a continuing monthly interest by your bill paying with liability notes. If you tried to pay with the BOE, you should register the original contract you signed because that is the equivalent of the unlimited credit access to the prepaid account. That is your asset in that transaction. If it is not registered, you can't show that the public should settle the public side of that accounting. If you send them a BOE that is unregistered, they will not accept it. They cannot see any public side to your BOE. Victoria has not been making monthly payments and she put the 3 criminal cases on a UCC filing. The BOE that you gave them in the criminal case is collateral. The case is not an asset, the case is a form to settle the transaction. The note should be put on the UCC. The criminal case is not settled because you have not made a claim. You have not put the note as collateral on the UCC. You are like a person in a mortgage foreclosure case that stops making payments and has not shown a continuing interest in the property by any filing in the public. Monthly payments would have been a monthly filing of a notice of interest. A notice of interest will expire if you don't renew it. The bank is foreclosing on you for presumed abandonment of the property. You didn't record your asset, which is your mortgage note that you gave them to begin with. The mortgage note is an asset to you and a liability to the bank, and you didn't record the note to make it a security registered in the public. Therefore, it is not cognizable by the public court system to give you a remedy when the bank did not close the full accounting with you at your escrow closing when you brought the property and when the note was closed off the bank's books on their liability side. You have no public claim. How can you claim the note as an asset when you give it to them? The note is an asset, like a lawnmower. If you give it to somebody, they owe you something back. You are the creditor in the transaction. You are the originator in the transaction. When you buy a house, you sign a mortgage note to the bank. You are the creditor. Did you give the court a BOE to settle the account in the current case? That was an original instrument, therefore you are the creditor. They owe you a receipt or a cancelled check. Like Roger Elvick used to say, you should receive a check. They didn't give the BOE back to you, because first, they closed the account on one side, otherwise they would be involved in fraud. But you didn't ask for the note back and they presume you didn't make a claim. It is a valuable asset, so they sell it to someone else. So someone else has a claim on that note that Vic used to settle her criminal case. Somebody is holding it. They bought it from the state. But they closed your account, the charges in criminal court, but only on one side. The case isn't settled because they haven't applied the funds from the note to the other side. They have not given you credit for your asset on your liability to close the full account. You have not made a claim. The receivable side is still open because the note does not show any public registration. They closed the private side that you gave them the note for, but you didn't get it back, because you didn't claim it, so therefore, they sold it again. So they are still trying to collect the receivables. They sold her asset to another company that holds her asset, so she doesn't hold it, and they are using the asset to create even more funding to run the corporations with. This is because they didn't ask them to give the note back and you didn't show that you have a public claim. You can ask the bank all you want to give your note back. The bank is not going to listen to you, because they assume that you are a debtor and they have no document of standing to show you are a creditor to ask for the note back. If we had registered it, we could certify it out of a public office, which they are required to accept. Just like you told the lady in the foreclosure suit, put the note that you gave to the bank that they are using in the foreclosure as collateral on the UCC filing. When she showed the filing to the judge, it shows I have a continuing public interest in the property. If you are not making the monthly payments, you have to have an instrument that shows you are still making a claim on the property. I am a creditor. I have this UCC lien. It shows that I am a creditor with the property as collateral. I am the highest level creditor on the property. The judge said, "Okay, it looks like you have priority. The reason they still have a wanted sign for Victoria is because you gave them the note. They settled the private side, so she doesn't owe them any more for the crime. They settled on the private side. They didn't give her the note back. We held it. She didn't show she had a claim to get it, but we have settled the substance of the criminal charges. So they settled the one side, which is their liability side, which means they don't owe her anymore, which means they recognize the substance of what she gave them. But if they gave it back to her, none of the rest of the transactions could continue, because everything is based on her credit line. So they had to create a presumption that they didn't have to give it back to her. 1. She doesn't have a registration that shows she is a creditor, and because it isn't registered, we can't close out the public side. Since we can't close out the public side, we may as well not give her note back, and we will sell that note to another corporate entity that can use it again anyway because she doesn't know to ask for it. They closed the one side just like the bank did the mortgage at closing in escrow. They don't want to hold any money anymore. This whole thing is done, but she never came and asked for her money withstanding, i.e., the note that got canceled. So consequently we will sell this liability to some other corporation as their asset. Now you have the right to make the claim that you are the ultimate claim on the closing on the criminal account. I want the case settled and I want the wanted poster down. They cannot take the wanted poster down yet, because there is a silent party in the background that holds the note. You don't hold it. Someone else holds it, so someone else has a claim, an account ready for collection as a creditor. The company in Hong Kong that bought the account receivable is the creditor with a claim in this case. The wanted poster is still up to show the investors public interest in Victoria to give public notice that they have a claim. If you don't show a public interest that you have a claim, you have abandoned it and they're going to come in for collection in court. If Vic isn't making the probation monthly reports, the Hong Kong company will bring her in. They are not going to show up in court. The county will show up in court to press charges as the servicing bank on the account that was purchased by an SPV. The SPV is the conduit to funnel the money to the Hong Kong Investment Corporation. But the investor is the true moving party. Edgar Bradley was federal probation in which he tendered a note to settle and close. Ed kept telling them he was the creditor. Why haven't you closed the account? The probation officer reported to the court that Bradley was not meeting the monthly probation requirements and asked to revoke his parole. He was brought in briefly to a magistrate in which they adopted the recommendation of the parole office and he was going to submit it to the judge. At that point he had the opportunity to rebut, do affirmative defenses or counterclaims. The judge agreed with the magistrate and told Bradley to report back into federal prison for 3 months because of parole violations. Edgar Bradley had already sent an IBO to the feds to settle and close the account. He had not registered as BOE, so he failed to make a claim. So they settled the private side, but because he can't show standing they did not settle the public side of the account. Since they couldn't settle the receivable side, they had to sell it to a foreign investor to avoid fraud. When they canceled the probation, the new investor in the background was the moving party. I assume that they put him in for 90 days to see if anyone was going to prove a claim. When nobody proved the claim, they let him out again, with 3 more years of probation. This is likely the security to protect the investment interest of the purchaser of the public account receivable. This is caused by the failure to register the note and file as security interest in the public sector to settle and close the account. Admiralty Maritime only has authority for execution of sentences for contempt for failure to pay a debt. He did not record his note in the public so the accountants can settle their claim. There is another guy in similar situation as Pete with the state tax authorities. The state hired an attorney to collect the accounts receivable after he tendered a BOE. The state needed to sell the account because Pete gave them the substance for closing. But Pete is in contempt because Pete did not register his instrument to allow the account to settle and close. Therefore, the punishment is to sell the account to a third-party investor for collection. They have to put up some notice of interest to protect the investor, which will appear to interfere with your rights and privileges as punishment for you for not allowing us to settle the account. They are not punishing anyone for violating the law. They are not concerned about monthly payments. They cannot take the wanted poster down because there is a silent party in the background that holds the note. The wanted poster is the collateral they are using to support their claim. If you want the poster taken down, settle the claim. They can make a claim with an unregistered security, but they don't have a defense if you bring a registered claim. That is why they are not picking you up, so that you will not make that claim. Your claim will close that account down. They want that investor to keep it open and enjoy the return. They won't pick you up, but they have the public notice of interest. A notice of interest does not have to be proven unless there is a claim against it. Victoria has been trying to buy a house in Australia, but it hasn't settled and closed yet, because she hasn't registered the payment in the public. She is concerned about a bad credit rating. They give you bad credit ratings when you don't pay your bills because you don't know how the system works. No one in the USA should have a bad credit rating because they have a prepaid account.